I'm James Michael Shaw Jr. I'm a partner here at Butler, Weimmuller, Katz, Craig. Most of my practice is defending insurance companies against bad faith claims. Probably the thing I get the most questions about are civil remedy notices, or CRNs for those of us in the biz. A CRN is a creature of section 624.155 of the Florida statutes. That's the statute that created in 1982 the cause of action for first-party bad faith. Starting in 1982, an insured could sue her own insurer for failing to handle a first-party claim in bad faith. Now, the trade-off by the legislature for creating that cause of action is that they also created a 60-day safe harbor provision. And that 60-day safe harbor period is kicked off by the filing of a CRN with the Florida Department of Financial Services. A copy of it goes to the insurer, and during those 60 days, the insurance company can cure the alleged violation and thereby avoid the lawsuit altogether. It never comes into existence. There's two ways to cure a violation. The first is to correct the circumstances giving rise to the violation. That's usually for if the civil remedy notice alleges the failure to do something other than pay the money. Most of the time, though, it's a failure to pay money, and the way to cure that is to pay the disputed amount. Now, sometimes you'll see a civil remedy notice that insists that the insurance company has to pay an amount that's higher than the disputed amount in order to avoid the cause of action. That's not Florida law. The Florida Supreme Court has held that the disputed amount is the policy limit and no more than that. Paying the policy limit or curing the civil remedy notice is not always what's appropriate. Some claims are not being paid for very valid reasons. And in those circumstances, the Florida Supreme Court has held that if you don't respond at all within 60 days, that it gives rise to a rebuttable presumption of bad faith. The statute does not say that, but the Florida Supreme Court read that into the statute, and that's now part of Florida law. So you do want to respond to one of them within 60 days, even if you're not going to respond by curing the alleged violation. The CRN itself has to be in a particular form, but the response does not. It generally takes the form of a letter to the complaining party, who's generally the insured or the insured's attorney. A question that I get frequently is the insurer required to give a copy of their response to the Florida Department of Financial Services? Every time we have asked that question of the department, they say, no, we don't want them, nobody reads them, nobody rules on who's right. But most carriers are just not comfortable not giving a copy to the department where the statute's not clear that you don't have to do that, or that you do. It doesn't cost you anything to give them a copy, but there maybe are consequences to not doing it. So most carriers will do it. What most carriers do is cut and paste the text of their letter to the complaining party into the space underneath the CRN on the department's website. There's a space where you can cut and paste your own text there, and that's generally what insurance companies do. Something that's overlooked a lot is that because CRNs are a creature of Florida law, if Florida law doesn't apply, then the statute doesn't apply, and there's no need for a CRN and no need for a response to a CRN. Florida law generally doesn't apply when the policy was issued in another state. So if you have a policy that was issued in another state and you get a Florida CRN, you're going to want to talk to your Florida Defense Counsel about whether or not a response is required at all. Another thing about civil remedy notices that kind of make them a friend to insurers is that if the civil remedy notice allegations are different than the allegations that are in the bad faith complaint that's ultimately filed, an allegation in the complaint that wasn't in the CRN can't become the basis for a first-party bad faith claim. So if there are allegations in the complaint that aren't in the civil remedy notice, they can be struck, or if the complaint consists of entirely allegations that weren't made in the civil remedy notice, sometimes the entire complaint can be dismissed, and we've been able to do that for some of our clients. So if you're being sued for first-party bad faith, one of the first conversations that you want to have with your defense attorney is about the civil remedy notice and the allegations of the complaint and whether or not those two things match up. That's all for now. Stay tuned next Thursday for more tips.